We've got a few folks we're still waiting on, but Victoria, what do you think? 30 more seconds, we'll get going?
Yeah, just 12:02. So Thursday before a long weekend, with the weather maybe not raining, depending where folks are coming from.
Yeah, lots of Kelowna, Okanagan people and lots of Lower Mainland. So yeah, hopefully we'll have a good one coming up. Okay, well, it's 12:02. We'll get started. I am Richard Johnson, a partner and co-founder of Ascent Employment Law, and joining me today, Victoria Merritt, my intrepid colleague, and we're going to be talking about bullying and harassment in the workplace. And I like Victoria's addition, how not to guide. So we're going to, as always, be focusing on both the legal framework surrounding the issues that we bring forward to you as employers and managers in your businesses. We want to make sure that these sessions are as practical as possible. So we give you the legal framework, we give you some practical advice, and today we'll focus on bullying and harassment. We invite you at any point during our session to please pop questions into the Q&A. And we have the chat function as well, but if you can put your questions in the Q&A, we'll make sure that we get to them as soon as possible. There might be a couple-minute delay as we talk through an issue, but we'll be monitoring that regularly. We want you to use it because this is your hour and a half when you've got us captive and ready and willing to answer any questions that you've got. We want to engage you. So please use that. I'm recording this session. I've hit record because if I don't, I will get in trouble because I'll forget. So we are recording the session. So if anybody wants the materials, they will be available after the fact. If you want to watch it at your leisure or just go back and review any of the material. So we invite you to keep an eye on that when we send the materials as follow-up. And before we dive into the session, we do want to acknowledge that we work and live on the unceded territories of the Coast Salish peoples, including those of the territories of the Musqueam, Squamish, and Tsleil-Waututh nations, and hold space for that. So, without further ado, Victoria, you ready to go?
Yeah, so
okay. I'll turn it over to you. Give us an intro. Who are you?
Oh, yeah. So my name is Victoria, of course. So I practiced in Alberta before moving out to BC. My practice in Alberta was a bit broader than just employment issues. So thrilling stuff like insolvency and debtor-creditor and foreclosure work. And then moving to BC, I started practicing just in the areas of employment, human rights, and workers' compensation law. So workplace law. My fun fact is that I won third place in the Alberta Youth Provincial Chess Championships when I was a youth, and I'm probably unreasonably proud of that accomplishment, which I think speaks to my nerdiness, and hopefully doesn't reflect my accomplishments since then, as I was saying. But yeah, that's me. I love helping employer side clients and employees, and policy drafting is a particular passion of mine. So this topic is always one where it comes up a lot, and policy help comes up a lot here.
Yeah, thank you. And that does not surprise me about your chess championship background because you are a master strategist to this day. So no shock there. I started my practice in Alberta and Edmonton, actually a stone's throw away from where Victoria started her practice, different firms which were directly head to head in the same practice area. So I was called in 2006 and called in 2007, I'm sorry, and then came out here and in 2010 and haven't looked back, loving BC and practice out here. And I, for the last number of years, have focused solely on workplace legal issues. So the lion's share of my practice has been human rights, labor, employment law, workers' compensation law, contractor disputes, independent contractor arrangements. And that's our bailiwick. So those of you who have, I was going to say had the fortunate privilege of working with us, it's vice versa, actually. Those of us who you've gotten to know in our work, you'll know that we focus on workplace law and workplace issues, and that's the lane that we love to travel in. And so Victoria and I have very similar practices. My fun fact is that I was Victoria did this. She called me a javelin champ. I don't want to say that I was a champ, but I was very big into javelin, working my way up to the national level, and still love to watch the Olympics and see how those who are more nimble and able to perform athletic endeavors, how they're faring at the Olympic level. So that's a bit about me. And then I'll give you a little bit of an overview. We're going to share the presentation today. But what we're going to first talk about is what is bullying and harassment as applied to the workplace context. And before we go to the next, and then we'll recognize the line between reasonable management and bullying and harassment. And that's always a bit of a conundrum for managers. What is the line between adequately overseeing and supervising and directing your staff and personnel? And when am I going to risk being called out on the carpet for bullying and harassment? We got to also talk about what to watch for when we're creating and implementing bullying and harassment policies. This is certainly something that Victoria is very keen on, being a policy wonk. She's always at the very forefront of what the law is saying we watch for and can do in terms of our policies. And then number 4, we'll talk about how to handle complaints in a timely fashion and in a responsible manner. So the keystone here is always going to be fair, or 2 of them actually, fairness and then risk mitigation. So we're coming into this session today all as employers and HR professionals, etc. And so we're looking at how do we manage processes in a fair way, but how do we also mitigate risk for our organizations? And so that's always going to be the line to straddle. What happens when someone escalates matters to WorkSafe BC, or when things don't get dealt with in-house fully and resolve? WorkSafe BC is the next venue. So we want to talk about what happens inside that body, and then how to deal appropriately with frivolous or vexatious complaints. And this is something that unfortunately many of us have dealt with before: employees who take issue with management decisions or have a legitimate issue on one front that may not be bullying and harassment, bring it into that context and try to use those processes inappropriately, and it's an abusive process. And so we want to talk to you about how you can manage those types of cases. So I'll pass it over to Victoria, who's going to take us through the definition of bullying and harassment.
Thanks, Richard. So this is from the movie Miss Congeniality, people who didn't recognize it. And I put it up just because I think it's an example of what immediately springs to mind when we talk about bullying, which is everyone learned about this in elementary school. You don't push other kids. You don't say mean things. You don't call someone dork brain. That's bullying. That's not okay. In spite of that, this continues to be a shockingly common issue amongst adults and in workplaces. So bullying harassment is alive and well. I'm sure it's something you've all had to deal with in the context of human resource issues. And so it seems a bit funny to start with what it actually is, because it seems like it should be obvious. However, when we look at what takes place in the workplace, it often tends to be much more subtle than the illustration on this slide. So sexual innuendo, workplace gossip, undermining someone's authority, an abusive manager, a really difficult, unpleasant employee. There's a lot more nuance to what goes on in the workplace than this sort of playground bullying. And like I said, it's actually much more common than you would think. You hear that noise on your side of things, Richard?
Like a rushing wind.
Sorry, yeah, I'm not sure what that was. That's in my house. Joys of working from home. Anyways, let me know if that becomes distracting on your end. So I have a few stats about bullying. So 2018, about 20% of women and 13% of men reported experiencing harassment. And a study from StatsCan in 2020 actually showed about 25% of women and 17% of men reporting inappropriate sexual behavior, which would fall under harassment. So not always easy to identify, but we have help. So to see it is to know it, not enough for the law. This is a great quote from Richard, I believe. And wouldn't it be a presentation from lawyers if we didn't look at legislation? So Richard, do you mind actually chatting about these pieces of legislation for 1 sec while I go deal with that noise?
Absolutely, I'd love to.
Thanks.
Yeah, so we had a bit of a, I don't know that I would call it a sea change, but we certainly had a change in 2013 come along in the context of bullying and harassment and some of these issues that we're going to be talking about today. So WorkSafe BC is the body in BC that administers or oversees the Workers' Compensation Act. So the Workers' Compensation Act has various divisions in it, various parts dealing with occupational health and safety, workers' compensation issues in general. So people get injured in the course of their work. How is that plan administered? And essentially, workers' comp, or WCB, is a statutory scheme. I think we're all very familiar with it, where instead of an employee getting hurt and suing the employer, they can claim workers' compensation as part of this, employer-funded, government administered program. And so, because occupational health and safety is subsumed in this this scheme, the Workers' Compensation Act is our touchstone for bullying and harassment. And in November of 2013, we had this requirement starting to come from WorkSafe BC that all employers have to have a bullying and harassment policy. Employees started to be able to make complaints or claims rather for mental distress. And so these types of behaviors that were playing out in the workplace became the subject of legislative change and therefore workers' compensation oversight. Now, the other facet of this type of scenario is that some of the issues that arise in the context of bullying and harassment will necessarily touch on somebody's disability or somebody's sex or their gender or sexual orientation or race. People don't act in isolation. So again, to talk about lawyers being lawyers, sometimes you parse things out into specifics, right? But people don't act in a vacuum. People behave in ways that try to pull others into their sphere and act as a group of meanies in the workplace and make comments about all sorts of stuff. So you might have somebody bullying and harassing, and it might also be discriminatory under the human rights legislation because it criticizes someone's race or ancestry or their age. Any of those human rights factors will bring in the Human Rights Code. So we look at things with those two facets in mind. So that's why I thought it appropriate to touch on those at the outset.
Amazing. Thanks, Richard. And it turns out they're watching the windows of my strata complex. So hopefully they're going that way and the noise doesn't get worse, but I'll let me know if that's becoming an issue and we can adjust and be flexible and adaptable as everyone has been over the past 2 years. This slide is titled somewhat facetiously, Why Do I Care? What is bullying and harassment? Of course, the answer to that is you care because you're all good employers and you're interested in having healthy and safe workplaces, and you know that employees that feel healthy and safe are more productive and retention rates are better and so on. But even if we have any Mr. Burns in the audience here, it is actually a legal obligation, as Richard was just touching on, to provide and ensure the health and safety of all of your workers, anyone present at the workplace where your work is being carried out. And so subsection 2 here concludes that you also need to provide workers with information, training, and supervision necessary to ensure their health and safety. And bullying and harassment, as Richard was just explaining, is now legislatively protected, and it is considered workplace hazard. And psychological safety, which was not really a concept not that long ago, has actually come to the forefront in terms of an employer's obligation. And again, regardless of the legal obligation, there's lots of reasons why you want to be working to prevent bullying and harassment. So returning to our definition, this is the definition from WorkSafe BC. We'll come back to this when we talk about policies, because this is a ready-made definition for you in terms of what constitutes bullying and harassment. And Richard might jump in here, but I think we often see employers who kind of crafted their own definition.
Yes,
and there are a number of definitions. Every province has their own in legislation. There's, Oxford definitions. In our point of view, if you're primarily dealing with BC legislation, it's easiest and safest to use the WorkSafe definition. Any comments there, Richard?
I can't tell you how many times we've opened up a policy manual or seen a complaint unfold, and somebody comes to us for advice, and one of our first questions is, okay, you got your policy, right? Either no or yes, and then you look at the definition of bullying and harassment, and it's completely not at odds with the legislated definition, but it's some very specific type of conduct, and so it affects the flow and the outcomes of an investigation, and it probably, in a lot of cases, would not pass muster if you ever were scrutinized by WorkSafe. So I couldn't agree more.
Yeah. So really, don't make it harder for yourself. Here's a definition you can use, and the definition is that bullying and harassment includes any inappropriate conduct or comment by a person towards a worker that the person knew or reasonably ought to have known would cause that worker to be humiliated or intimidated. A few different parts to this definition. Inappropriate conduct or comment. I mean, this is not always that straightforward, but fairly straightforward. So insults, sending someone an inappropriate photo by email. And then the second part of this would be by a person. So this actually includes any individual, regardless of whether or not they're part of the workplace. So people coming in, clients, you can think of certain industries where there's a lot of client events and mingling. Your employees, how they're treated at those events can fall under this definition. Members of the public coming into your workspace. We've seen in COVID, when there's poor frontline staff have dealt with some pretty inappropriate behavior. So this piece of the definition is actually quite expansive in terms of who the bully can be. And then it's towards a worker that the person knew or reasonably ought to have known. Now, reasonably ought to have known is a phrase lawyers and judges love, because it means it doesn't matter if you go, oh my gosh, how was I supposed to know that so-and-so was going to be offended by my joke about the Easter bunny? I didn't know they were religious. I was just being funny. I didn't know. It doesn't really matter, because the test becomes, is it something you should probably have known, or a reasonable person would have known? Or if you took that step back and thought about what was going on, the conduct or comment that was being made, would it be reasonable to decide someone would be offended by that? And then, of course, the last piece is that the behavior has to cause the worker or to be humiliated or intimidated. And again, humiliation, intimidation, fairly straightforward. Richard has his hand up.
Thank you for calling on me. I just wanted to flag just a couple of ways that this manifests itself in circumstances that we don't always think about. If I could, I don't want to steal your thunder, Victoria. I just think the one thing that struck me when I first started to analyze this definition as, somebody who does WorkSafe issues or WCB issues, we think about bullying and harassment as something that plays out between workers. I think that's the common conception of bullying and harassment in the workplace, but it's far broader than that. And again, one of the common things that we see in practice is you've got a general contractor and subcontractors, or you've got a retail store. And bullying and harassment addresses those situations in ways that you don't expect. Somebody comes into the parts counter at your auto shop and says, "What's this, blah, 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 blah," to the staffer who's on the counter. And "I want to talk to a manager, you're being a jerk." Or says something about their race or their sex or what have you. That's bullying and harassment in the workplace, even though the perpetrator or alleged perpetrator is not They're not somebody who is a worker. They're not even necessarily under a contract at that point with the business. People who are working as subcontractors in a work site could be bullying and harassing one of your employees, and that still triggers our obligation as employers. As long as one of our people is being bullied and harassed, it really doesn't matter who's doing it for the purposes of engaging our requirement to act. I just thought I'd flag that because that's pretty profound. So if you want to think about how this plays out, really cast a broad net in terms of who could be captured by this.
Yeah, that's a really excellent point. And actually a lot of the case law, for example, sexual harassment, I would say is an area where this comes up, where it's not actually an issue with a coworker or anyone in the workplace. It's going to be a client, right? Or you're at a conference for the weekend, or you're at a lunch with clients as part of your job, and something happens, and that can still fall within this definition. So it's definitely a good idea to, again, think of the scope of this. And so not just in terms of who, also in terms of the conduct that might be at issue. So email and social media has also been another area of problems, I guess would be the simplest way of putting it. So it's not just, that in person. It's funny, if you Google images of workplace harassment, you get that stock photo of like often a male manager yelling at a female employee when they're at their computer typing. Yeah. That's really not most cases of bullying and harassment that we see. It's the people involved are more complex, and usually the conduct at issue is more complex. So certainly this definition is actually quite broad. Anything else to add on the definition before we move on?
No, I mean, we talked before this presentation that this could be 10 hours of material that you could discuss because it's human conduct. But I think you make a great point about social media. So the more complex our workplaces become, and the more remote and the more IT stuff that we use, and the more Facebook and Twitter and LinkedIn and all of that's being used, the more you're likely to find that some of this inappropriate conduct is comments or ganging up in a social forum. So it's technologically, it's technical conduct, it's technological conduct, if that makes sense. So we're seeing the ways it plays out to be a lot more insidious.
Yeah, insidious is the perfect word. And the pandemic, which, one day, hopefully we won't be talking about every issue in the context of COVID, but bullying and harassment didn't actually go away. And in fact, the isolation and sort of blurring of lines from remote work, I think, caused its own unique problems. And again, a lot of those go back to the use of technologies. Also, a few people joined us. So if you have any questions, please use the Q&A chat and feel free to ask them as we move along. Both Richard and I will keep tabs on that. So that's sort of what I would say is the easy part of the definition, notwithstanding everything we just talked about here. The trickier part of the definition, and one that I think a lot of employees are a bit shocked by, as a firm that also does plaintiff side work, is that bullying harassment does not include, and this is again the second part of WorkSafe BC's definition, so should absolutely be in your policy. So it does not include any reasonable action taken by an employer or supervisor relating to the management and direction of workers or a place of employment. Now, this is a very important exception because it preserves your ability as an employer to manage your employees. And obviously, this comes up a lot in the context of performance management. And I'm sure you have all dealt with employees who feel that a manager who's trying to performance manage them is bullying them or harassing them or targeting them unfairly. And again, this is an area that becomes quite challenging and is, I think, where we see a lot of complaints. There's some obvious ones, the employee who's just disgruntled because they're put on a performance improvement plan. That's not bullying. But it gets a bit tricky in terms of what's considered reasonable actions. And there's actually not that much guidance in BC legislation. Interestingly, PEI actually includes a list of actions that are not considered bullying harassment if done reasonably and fairly, which I thought was quite neat. And so it's just illustrative. So some of those included changing job duties, scheduling and workloads, instructing workers, evaluating work performance, and disciplinary action. And again, there's a caveat on that list, which is it has to be done reasonably and fairly. But I think those are good illustrations. They're not in the BC legislation, but I think they're the sorts of things that WorkSafe would also say, yeah, it's not bullying to change someone's schedule or to ask them to come in and cover a shift. So where this gets tricky is that you can have a bad manager who's not a bully, but that might generate bullying and harassment complaints. And if you have multiple complaints against the same manager, you might want to consider, are they taking reasonable actions, or is this crossing a line somewhere? And one thing, I mean, if you watch any, Mad Men or any sort of historical work movie, work culture's changed. So, you have some generational management styles that might be, so yelling, I guess, would be one example where typically raising your voice in a workplace is probably not going to be feasible in most circumstances. Insulting an employee or using really demeaning language, you're going to run into problems. And this is where, it's tough for employers because you need to provide careful training to your managers on what good management looks like. And that means you absolutely can criticize employees for their work. Hey, this is, there's too many typos here. This isn't the sort of work product we send out. That's fine. But, you're so dumb. How could you possibly do this? You keep making this same mistakes. As soon as you're getting into that personal insulting language, you're going to run into issues. So it's very tough, and it's very much assessed on a case-by-case basis. But I think a takeaway for employers is to look for those red flags, which would be, I think, multiple complaints against a manager, or people often sort of trying to switch out. The flip side of that would be if you have an employee who's complained about every manager they've ever had, probably going to be the employee who's a bit problematic rather than the other way around. And it's not, again, this exception is meant that workplaces are not all sunshine and rainbows. And you all have businesses to run and objectives to achieve and expectations of your employees. And that's all reasonable. And performance management is not bullying.
Our clients' workplaces are.
Sunshine and rainbows?
All the time.
Yes. With no problem employees, right?
Right.
We never hear from anyone. Anything to add to this? This is a sort of topic we could talk about forever. And I think probably forms the bulk of complexity on bullying and harassment cases. But I'm curious, Richard, if you had anything else to add to this one.
The one thing that I would add as you were speaking is objective versus subjective. And I know lawyers will almost always say document, document, document. We don't want people to walk around workplaces, employees or employers, recording each other or, with a notepad, scribbling down every comment. But if you've got an objective concern that relates to the job, that's a good indication that it's probably a reasonable action that you can take to address that. If it's a subjective action, or you're acting on your feelings, I know this seems trite, but if you're having a bad day and you yourself are managing people, but you're off your game, or you're just not having a great day and you're lashing out, that's probably not a reasonable action if you yell at an employee. So it's this objective versus subjective, and that's also where some of these complaints will go, and it will come down to how much you've documented, and then how much is really an objective or subjective action that was taken or a concern that exists. And so documenting things and having good processes that way can really be important. But we'll get to that when we talk later. It's just something that came to mind.
Yeah, absolutely. And the objectivity, subjectivity piece is also important for employees.
Absolutely.
Right. So this sort of acknowledgement, and this, can be dealt with in workplace and bullying training, or workplace harassment and bullying training. But employees, feeling a certain way doesn't necessarily mean so you can be embarrassed by a performance review, for example, but it doesn't mean you were bullied in that performance review. So again, that's something that I think good, effective workplace training should address. So subject to any questions that I don't see in the Q&A, move on to a few further legislative details, because lawyers love legislation, which is where all of the rules you're expected to follow come from. So WorkSafe BC is 3 different policy items, basically broken out into employer duties, worker duties, and supervisor duties. It's always refreshing for employers to remember that it's actually workplace safety is a shared duty. So it's not all on you as the employer. Workers also have their own responsibilities around a safe workplace, and that includes around bullying and harassment. And for both workers and supervisors, there's basically 3 really simplistic steps. 1, don't be a bully. So don't bully or harass your coworkers or other people. 2, report bullying and harassment. This is much trickier. This is where, again, training needs to look at things like bystander intervention training, how to recognize bullying and harassment. And again, this gets very tricky when you have things like a group Facebook conversation, where one employee is getting teased. That bullying and harassment, it might be, do you want to be the employee who reports that to your employer? Maybe not. And of course, the 3rd is to comply with the employer's policies on bullying and harassment, assuming the employer has them, which I'm sure you all do. And we'll return to the employer duties in a bit more detail momentarily. But before we go back to WorkSafe BC, Richard, let me know if I'm overlapping with anything you said while I was dealing with the window washing, but the Human Rights Code is very much at play here. And that's because a lot of issues with bullying and harassment are going to overlap with discriminatory conduct. The most common example of this would be sexual harassment, for sure. So sexual harassment is bullying and harassment, but it's also going to fall under the Human Rights Code. But there's other examples, even excluding someone and that person happens to be the only person of color in your workplace. Again, age, actually, right? Making jokes about the old guy in the office. Again, we're running into a protected ground. So it actually overlaps quite often. And Richard's going to talk about the fact that you can have multiple processes going on at once. Again, some of you, I'm sure, have dealt with the multi-jurisdictional complaints where an employee's filed multiple complaints about the same issues and can proceed with them. So Richard will get into that. But it's just always important to bear in mind that you're not just dealing with health and safety legislation, you're also dealing with the Human Rights Code. And I like doing policies that deal with bullying, harassment, and discrimination sort of together. I know, Richard, a few thoughts on that, but they often overlap. So having a process where you can report bullying and harassment, and it's clear that that encompasses discriminatory conduct, kind of addresses this.
Yeah, I totally agree. And if you can dovetail and make things more efficient from a logistics standpoint and a policy standpoint, that's practically beneficial for the business.
Right. So I said we go back to employer obligations. Broadly speaking, the overarching duty is to take all reasonable steps to prevent where possible or otherwise minimize workplace bullying and harassment. And again, this language is important because step 1 is let's prevent it. Step 2 is we all live in a perfect world. And even though your workplaces are all sunshine and rainbows, to go back to Richard's comment, workplace bullying and harassment does take place. So then the expectation is how do we minimize that and how do we address it? More specifically, these are the 4 sort of steps. And so number 1, having a policy statement that confirms bullying and harassment is not acceptable or tolerated. 2, again, this is taking steps to prevent where possible or minimize bullying and harassment. And then 3 would be developing and implementing procedures for workers to report bullying and harassment, so a reporting process. And 4 is, of course, procedures for how complaints are actually going to be addressed by the employer. So it's not, I actually think WorkSafe BC has done a relatively good job in this area in terms of keeping the obligations fairly clear. I was waiting for Richard to go. What? But
No, I would agree with that. I mean, for a body that can get pretty bureaucratic pretty quickly, with all due respect, I agree. I think when you pare it down, the responsibilities are pretty clear.
yes, and these responsibilities are almost all met by just having a bullying and harassment policy. And they're going to be all met if you have a policy that's actually followed and that your employees know about. So we're going to get into kind of the meat and potatoes of the presentation, I would say, which would be policies and actually handling complaints. So creating your policy, the definition, we've already talked about this. There's no magic to it. If you work primarily in BC, using the WorkSafe BC definitions, great. If you're a multi-jurisdictional employer, this can get a bit tricky because there's little changes, little differences between each province's legislation on this point. So it's a good idea to get advice if you are in multiple jurisdictions. If you're not, don't make work for yourself. The WorkSafe BC definition is actually very good. The policy needs to set out expectations for the employer, for workers, and for supervisors. And again, you can rely on a lot of the language from WorkSafe BC on this. Forms, it's nice to have a complaint form that you can have attached to your policy. Oh. And we'll talk about creating the policy. I wanted to take a step back though. So for all policies, there's a few guiding principles. One would be consistency. And that means both internal consistency, so within the policy itself, you're consistent, and then that it's also consistent with any other pieces of policy you have and your employment contracts. So again, it's just kind of making sure everything lines up in terms of definitions and expectations, so there isn't confusion created between documents. Clarity for policies is important. That again, is just plain language drafting. You should be able to read it and understand and look at the process and go, okay, if I was an employee, it's obvious to me, here's who I report it to, here's how I report bullying, and then here's the steps that the employer will take. However, mixed in with that is the importance of preserving your own discretion to address things on a case-by-case basis. So policy drafting is sort of a balance between being specific and clear enough that it's meaningful and provides guidance, but also leaving yourself room to deal with the wide variety of complaints that might come in, whether that's the frivolous and vexatious complaints, right up to, you actually have an employee who's been charged criminally with something that took place in the workplace, and you have a really serious health and safety issue that's going to be need to address completely differently than the complaint about your manager, yelling at employees or being overly negative or demeaning. So preserving your flexibility and your discretion is also important. Richard, unmuted. Do you want to jump in?
No, it was just some folks outside of my office were being loud. But what I was going to say in terms of that is just the creation of the policy and the definitions that you use and then the manner in which you carry it out requires that we really think of our audience. And so bullying and harassment isn't isolated to a certain industry or a certain socioeconomic group. This behavior is human. I'm not trying to excuse it, but we find that it plays out amongst all types of office environments and work sites and construction and food processing, whatever it is, right? But think of your audience, because not all of your audience will necessarily have a diploma or a degree or a certain reading level. And so that's really important. I'm preaching to the converted in respect of Victoria being a huge advocate of plain language, because she reminds me of this all the time as I use my heretofores and my Latin maxims. So something that came to mind for me as you were talking.
Yeah.
When you're drafting it.
Yeah, that's so important. And policies, there's no magic. For example, the title, there's no magic to what you call the policy. So respectful workplace policy, bullying and harassment policy, bullying, harassment, discrimination, and violence policy. There's no magic to the title, but again, you want to be consistent if you are using one title for it, and it should be obvious sort of what it's covering. There's also no magic to the policy statement. And sometimes less is more on this, because as you'll recall from the WorkSafe, from the actual legislation and their policy guidance, it's really just saying we don't tolerate bullying and harassment in our workplace. So don't bully, report bullying, and comply with their policy. It really can be quite that simple. What's more challenging, what Richard's going to talk about a bit more, is what do you actually do when you get a complaint? And again, I'll let Richard talk about the mechanics, but those mechanics need to be set out in your policy. And this is where balancing the level of detail and enough guidance that an employee has some expectations around it without tying your hands to respond to different complaints differently. So chain of reporting, very important that there's at least two names for people to report to.
Yeah.
One would be, their supervisor, their manager, your HR person. The other would be if the bully is your HR person or their supervisor, who do they go to? So there needs to be an alternate, basically, but you also don't want to make this, you can report to anybody, because now you're saddling employees who don't potentially have the authority or knowledge to deal with these with potentially getting a complaint. So you want to be clear in terms of who you can report to, how you report to them, how confidentiality is addressed, what your investigative process and timelines are. And again, this is where you don't want to be overly specific. So we will respond and retain an investigator within 24 hours. That's probably not going to be possible. And it's probably not necessary in most cases. Nor do you want to say every complaint will be investigated by an external third-party investigator. Because again, that's not always necessary. And it might be really costly and a bit of overkill for the problem. What happens in the meantime to the alleged victim and perpetrator? This is again a safety issue. And then of course, what happens afterward? And again, these are all things which we're going to talk about. And they're things that you want to address in your policy, but not with too much detail. I feel like I'm talking about Goldilocks. You want it just right in terms of the amount of detail for yourself. So with all of that, I'm going to flip it over to, and outcomes and sanctions, basically what happens afterwards. I'm going to flip it over to Richard. Oh, I guess this is also my slide, Richard, but I think you might talk about this too. Basically, this goes back to what we said earlier, which is your policy is only as good as your implementation. So implementing it consistently, offering training, and then actually following your policy. And it actually continues to be shocking to me how many times we have an employer come, and Richard can maybe speak to this as well, but you have the phone call and they say, this is what we've done so far. And question number one we'll have is, okay, well, do you have a policy? And what does your policy say? And the policy is not just for employees to know what to do, it's also to help you and your HR person and whoever is in charge of implementing this. So remember you have your policy, reference it for employees, train your policy. So when you do bullying and harassment training, reference your own policy and follow your process. And then if you need to make changes after going through it, you'll know. And get advice. And this would particularly be the case, I think, where there's a major health and safety issue. So we'll leave this slide in the materials, that last one, but that was just a summary from WorkSafe. I'm gonna move it over to Richard, and I'm gonna let the whole slide go up, Richard, rather than one at a time, if you're fine with that.
Yeah, absolutely. Yeah. Thanks. Really good groundwork and really important stuff to remember. So coming into the situation, we're going to assume the existence of a policy when I go through in detail next steps, but okay, am I unmuted? There we go. That should be good. Okay, so yeah, we're going to assume the existence of a policy as I go through. And I want to just reiterate that Ascent takes a really practical point of view when it comes to our relationships with employers. We want to be able to be at the ready and on call to help as things come up, but we don't want you to feel like every single instance needs you to reinvent the wheel and to create things out of whole cloth. So that's why We advocate policies that are built around your specific organization. It is mandated that you have a bullying and harassment policy in BC, but that's the only one that's mandatory. Otherwise, take a look at your organization and see what you need. And then once it's in place, we're here to help apply it. But we don't want you to feel beholden to a lawyer where you've got to have them on speed dial paying tons of money all the time. So hopefully things like this session will help you to explain the nuts and bolts, and then you can flesh things out, and we're here to help as you go through. But you've got a situation that's arisen, you've got a policy in place, and two of your employees aren't getting along. I'm just going to use that example, even though it's the colloquial or the quintessential thing that we all think about is two employees fighting, or a manager fighting with a subordinate. Okay, so let's assume it's two people inside your organization. Somebody brings forward a complaint saying, I've been bullied and harassed by my manager. You do want to move quickly, but what quick is will depend on the circumstances. So if you've got a situation where you have sexual harassment and somebody is being harassed or potentially assaulted in the workplace, that calls for an immediate minute. Like the scale of your response should be minutes, maybe hours, but you're not leaving that to sit for days. And so what do parents do when children are squabbling? I don't mean to be trite here, but you go in and you separate. That's almost the type of thing that you're going to need to do immediately in your mind is, okay, how do we get the alleged victim to feel like they are moved to a safe space without being unduly paternalistic? We may want to provide them with an opportunity to be off of work immediately, effective immediately, without any without it being viewed as retaliation or that they somehow are being double victimized. So your response needs to be swift in those types of cases, but at other times, maybe it's a situation that's ongoing and it's like death by a thousand cuts. This person is describing behavior that arises every management meeting, which is once every 2 weeks or something like that, where there's a bit more leeway in terms of time. So judge your response time based on the circumstances. And then investigation is almost always necessary of some sort. So fairness in our system dictates figuring out the facts and providing an opportunity to test the facts. And so what do fairness and proportionality and your policy, which will be based on fairness and proportionality, what do those require in terms of what's fair to the potential victim, what's fair to the alleged perpetrator, and giving everybody the information and the safety that they need to move forward in the process. And those aren't just buzzwords. Those really do mean a lot to people when you're actually carrying out these types of situations and overseeing them. So perception is a reality for a lot of people. So even if at the end of the day, your investigation gets to a conclusion where, yeah, there's really no bullying and harassment, the person may very well feel like they've been bullied and harassed. So just bear that in mind. Perception's reality. And a lot of these things can hover around mental health in the workplace. And so I can't understate it or I can't overstate it enough that sometimes mental health will manifest as people perceiving them to have been harassed or bullied or being mistreated in the workplace. And so you're going to need some tools to deal with that. But your investigation will dictate pretty quickly what's going on. Okay. You don't have to, as Victoria said, deal with a third-party investigator. So we want to give you the tools to assess an issue spot. So is it a sexual assault, a sexual harassment? Is it a substance abuse issue that's underlying maybe a bullying and harassment situation, or somebody's acting out because of some other factor? Those might require that you bring in a third party because it's cleaner or because they have specialized knowledge or expertise. But WorkSafe BC has made it clear in their decisions that you don't need a third-party investigator. You're not mandated as an employer to go spend thousands of dollars getting somebody brought in who's a specialist in doing these. So figure out if you got the tools and the expertise internally, and figure out if you got the bandwidth. You know, if your budget is robust and you've got time for time and space and money for a lawyer, an investigator, and you don't have the time to deal with it because you're the HR person and you're busy, then maybe it makes sense to get somebody to do it. But don't feel you have to. Are the alleged victims and the perpetrators being given a fair opportunity to address allegations? Victoria is going to want to just ignore what I'm going to say here for a second. We have a maxim called audi alterum partem, and that is basically the right to be heard. And it plays out in a whole bunch of different contexts, but people at law have a right under natural justice principles to be heard, to be given a fair shake. And that might play out in a trial or a tribunal process where somebody's giving evidence before the residential tenancy branch or something like that. It also plays out at work to some extent, where you want to make sure your process gives the victim a chance, alleged victim, I'm sorry, a chance to speak their piece and tell you what happened. But then you need to give due to the alleged perpetrator and also say, you have been alleged of X, Y, and Z. What do you say? And they may bring up facts that are relevant, or they may bring up other situations that come to bear on what really happened. And only by giving everybody their fair shake and giving them the chance to be heard can we effectively handle complaints. I'm just going to check the Q&A here really quickly. Could you speak on the difference between harassment incident and violence incident? That is a fantastic question. And I don't like just putting stuff off, so I'll just deal with that right away if I could, unless you have thoughts, Victoria.
No, I was just going to pitch that to you because it's a great question. And I think now is actually a perfect time when you're considering how do you handle or respond to the complaint, and that's dependent on the type. So take it away.
Yeah. Fantastic. And life occurs on a spectrum. Stuff can be, we all can identify that stuff is of lesser urgency, and objectively the harm that would exist in a certain situation, we can kind of assess that as human beings with knowledge and experience. And so if there's a violent incident, if someone has been hit or struck or their physical person is in jeopardy, that calls for more urgency. Violence in the workplace is another manifestation of bullying and harassment in many cases. And it's another type of conduct that's addressed under these types of policies and WorkSafe's oversight in general. So it's kind of on the worse end of the spectrum, if I can put it that way, I don't mean in any way to trivialize it, but it's on the more urgent end of the spectrum, the more grave end of the spectrum of workplace bullying and harassment and employee misconduct. And so violence seems to imply that somebody is acting out physically. So the actions are more pronounced. Somebody's acting out physically as opposed to using words or using, a keyboard to say hurtful things about someone else. And that can call for a swifter response. And that also might lend itself, when we get to talking about ramifications, assuming that violence in the workplace is proven, that in a lot of cases can start you thinking about just cause for dismissal. And so we might talk about performance management if somebody is making chippy comments. If somebody's walking around and they're actually getting to the point where they can't manage themselves physically and they're hitting people or slamming doors or hitting their desk. That's the kind of conduct that is, at a minimum, it's jarring and creates fear in their coworkers. But beyond that, it can lead to physical harms. So we need to act on that very promptly. I hope that I've answered that question in terms of the spectrum analysis. So it still falls within what we're talking about, but you really want to be quick to respond to it, and maybe the RCMP should be put on notice. You might have to make a police report if it is a violent incident in the workplace.
Yeah,
and you address that in your policy.
Thanks, Richard. That was going to be my only additional question for you, or nuance to this, is it might trigger different reporting obligations if it's a safety concern. So both to the RCMP and in some cases to WorkSafe, depending on the nature. And it's probably something where you want to get advice right away, I would say, if there's an instance of violence.
Yeah, that's a great point. And I'm going to say a little bit later, I'm going to talk about WorkSafe claims. And so depending on the context of the workplace violence, it may be a work-safe claim. So the person who's hurt or injured as a result of the workplace violence may have a WCB claim through WorkSafe. And so that might be the avenue that you choose to pursue, but it doesn't mean that you don't then have direct, you have to deal with the perpetrator outside of WorkSafe. So it can be there can be a bunch of different stuff going on at once. Who are the witnesses? So again, workplace violence is a great example where you in a lot of cases will say, okay, did anybody see, alleged victim? Can you tell us anybody who might have witnessed the conduct you're complaining about? Were they included on the email chain? Were they in the office when the door was allegedly slammed or when the words were spoken? Or are they a member of the Facebook group where you were talked about in unfair terms? So listen to the alleged perpetrator, listen to the alleged victim, and figure out who also might be able to be a witness, because that can speak to the truth of what's being alleged. Corroborative witnesses, support the allegations, and then there are other witnesses who will actually say, yeah, that didn't happen at all. That's not the way it went down, and that can also be just as important. And then once your findings are made, so once you go to the alleged victim and you go to the alleged perpetrator, and maybe you circle back with people once you get more information, then you also want to provide the alleged perpetrator a final opportunity to respond and just put any final comments or allegations to them. And make sure that you're wrapping this up with those principles of fairness in mind. Maybe at the end of the day, Victoria and I just did an investigation, and it was it was very very much on all fours with what we're talking about here, like very square to the situation that we're talking about, because it was two, some people who worked together in the context of a workplace, and there was an office environment, and stuff happened and was alleged to have happened, and so you've got to make findings, and so you will go back to making findings and then figuring out what to do once you've assessed what happened based on the evidence, and you're making your best attempt to come to a conclusion based on a preponderance of the evidence, as they say in the US, or a balance of probabilities, as we say up here. Is something 51% likely to have occurred as opposed to 49%? If it's more likely to have occurred on the evidence than not, then that's the standard we use, and we lean in favor of then finding that it happened, and then what are we going to do about it? And your policy will dictate what kinds of options you might have to deal with a perpetrator. So is it going to be a disciplinary letter? Is it going to be immediate dismissal for violence? Is it going to be a suspension, which the courts don't generally like? And so we got to be careful that we're giving ourselves enough flexibility in our discipline processes that we can jump straight to the most serious disciplinary action, which is dismissal for just cause, but also tailoring it toward the circumstances and being fair to everybody in the meantime. And then you do have an obligation when you do an investigation. You gather all the information up, you figure out what you think happened, you make your findings, as a third-party investigator, we would go back to the employer and make some recommendations. But there's an obligation that the employer has really to go and give at least a wrap up to the two main parties, or however many you'd have, who come from the victim side, allegedly, and come from the perpetrator side. So you go back and you tell people whether or not there's some or all of the allegations are substantiated or not substantiated, or substantiated in part. So did something happen or not, or some of what they said happened. And then you leave it to the business to decide how they're going to move forward on the discipline, and we can advise on that. But those are all options that you have under your policy. And so I'm just going to see if anybody has any questions, please throw them into the Q&A. But once things play out internally, that may not be the end of the situation. In some cases, you may find that employees take it upon themselves, once they're aggrieved, to go and make a complaint to WorkSafe BC. And sometimes that's merited. And maybe they have suffered some mental distress, or they've suffered a workplace injury as a result of the bullying and harassment. And sometimes they're using it as a tool to leverage an outcome, and they have an axe to grind. And unfortunately, that's part and parcel of having these tools available to employees, is they can use them in all sorts of ways, but you do have rights as employers. So we'll go through those now. When somebody makes a complaint to WorkSafe BC, we will find that they will look at their mandates under occupational health and safety. And so they have a mandate to be concerned with occupational health and safety and to maintain reasonable standards for workers in BC and employers in BC. That's their mandate. They have a lot of power to make regulations and set standards, whether it's as simple as you have to make sure people who are working in a construction site have hearing protection to X level of decibels, or you can't allow bullying and harassment. So from the micro to the macro, and they can do everything in between because they're mandated by legislation. They can come in and do inspections. They can do investigations, not workplace investigations like we're talking about, but they can investigate whether there's been a breach of their legislation, and they can make inquiries. So that's pretty broad. They can go and ask questions. And part J there, I quoted that because the specific language is that they can provide assistance to persons concerned with occupational health and safety and occupational environment. So they will provide a lot of tools and advice and guidance to those on safety committees, for example, in the union context, or to people in the construction industry. And so they've got a wide mandate to assist to implement OH&S. But the main thing is that they will start to become involved and maybe move down the road of accepting a claim if a personal injury or death arises out of and is in the scope or the course of a person's employment. And then compensation is paid out of the accident fund. So this is the crux of WorkSafe, right? Somebody's injured or they die, unfortunately, and that situation arises out of and is in the course of work, then WCB comes in. And it's a relatively similar framework in all provinces across the country. This is BC. And so section 134, you might know it as section 5 under the old legislation before it was changed in 2019. And that's really what we become concerned with if somebody escalates to WorkSafe is, do they have a personal injury or did they die? Typically, we're not dealing with death, thankfully, in bullying and harassment. The people are still with us. So it's a personal injury, potentially, mental distress, shock syndromes, those types of things. And if it occurred in the workplace, then that can trigger enough that a claim is made. And then we may have as employers a duty to report the injury or illness. So back to that violence in the workplace scenario. If you've got violence in the workplace that you know has impacted someone, it's almost certainly going to touch on their work. If it happened in the workplace between 8 and 5 or whenever you're open, it probably is a workplace nexus, as we call it. There's a linkage between their work and this situation, so that triggers that. And then if they've suffered some sort of medical consequence, just like a cut finger or any other medical issue, you want to make sure that the employee and you report to WorkSafe. And so sometimes that's done through what we're familiar with, the teleclaim or the electronic reporting system. But you want to be telling your employees, go make a WorkSafe claim if you think that you're suffering a medical consequence. And then that will allow it to fall under that statutory insurance scheme, as opposed to them coming back to the employer saying, you're on the hook. Okay. And then employees need to follow your policy first. So I'm going to go into this in a moment, but one of the important things is that employees have to avail themselves of your policy and your complaint mechanism first. In preparing for today, Victoria and I were talking about this and just the logistics, and they're really clear at WorkSafe that they want you to go through your internal mechanisms of recourse first. I think there's a practical reason for that, and I think it's threefold, actually. I think the first thing is they want to make sure that they're not dealing with every workplace issue. So just practically, put a policy in place, put a practice in place at every employer, and then WorkSafe is not going to have to spend the taxpayer's dime dealing with every grievance. But more than that, they want to make sure that industry has some autonomy to properly deal with worker issues and managing workforces. And that's why they won't chime in on true managerial decisions that are made reasonably. And so they want to provide autonomy, and they want business to continue on, but they got to make sure that people are safe. So this is where the education piece comes in. You've got to tell your people about your policy. You need to train your people. You can't put a policy on a shelf and have it collect dust, even an electronic shelf. And you could distribute it, but you know it's basically sitting there collecting virtual dust, right? So there's an important aspect of this, and that is to constantly be providing people with the tools to ensure that this doesn't come up, and that they know what their rights are, and that their reporting obligations are clear. And then you can look back and you can say to WorkSafe, oh, everybody knows what the obligations are under the policy. So if somebody does have a concern about bullying and harassment, they can go to WorkSafe and they can fill out what's called a questionnaire. And so under section 17.1 of WorkSafe's the mandating legislation, they can undertake investigations and inspections and inquiries, and they can look into complaints of health and safety in the workplace. So you can go on as an employee and you can fill out a bullying and harassment questionnaire, and that may trigger WorkSafe to come in and start asking questions or do an investigation. But you're going to have done your legwork as an employee first. Next slide. The purpose of the questionnaire, and this is from WorkSafe's materials. So I can't take any credit for the wordiness of any of this or any of that. This is directly from the website, but they gather information from these questionnaires, and then they can look into bullying and harassment, but they won't look into these issues unless they have reasonable grounds to believe that an employer didn't do what they were supposed to do. So they do leave it up to employers to follow the requirement to have a policy in place and to follow that policy. And then you have to report as an employee, you have to report bullying and harassment to your employer before submitting the complaint or the questionnaire. So that's really, really important and should provide, I hope, some comfort to employers that WorkSafe's not out to get us. It is a pretty reasonable standard. And then their role is not to mandate an outcome or to mediate disputes between employees and employers. That's not their job. They have mediation. They've got people who do that in the context of certain types of complaints, not this. They receive a complaint, they receive the information, and then they assess it to find out if an employer did what they were supposed to do under their policy and under their requirements under WorkSafe. And if they didn't, then they can get their knuckles wrapped as an employer. And if you don't have a policy, you're going to be called out by WorkSafe. But they do give us a lot of leeway as employers to properly manage our workplaces. And then if something does escalate to WorkSafe, the employee will have to provide that assurance that they went through the steps and they weren't acted on, and the employer's not doing what's fair. But I know that wouldn't be any of you out there anyway. Any questions at this stage, please, I do urge, raise them. But continuing along the path of escalation, we sometimes will find that employees will make what's historically called a discriminatory action complaint. I put that in there as the phrasing, but it's actually called a prohibited action now. WorkSafe doesn't allow retaliation. So if somebody acts in good faith and makes a complaint to WorkSafe or raises a safety issue to their boss, and they're retaliated against for doing that, that used to be called discriminatory action. Now it's called prohibited action. The reason they changed it is because everybody was making human rights complaints to WorkSafe because of discrimination. And there was some confusion about discrimination in the human rights context, racial discrimination, sex discrimination. So they changed the lingo, which is a great idea. But you can't retaliate against people. And so that's where your policy can also provide a nice framework. And if you just follow it, information collect, provide people an opportunity to respond, make a reasoned assessment based on objective criteria, And then you're not going to retaliate against people for raising safety concerns unless you find on the evidence that they're acting in bad faith, that they made a complaint to get John or Jane. And if you find that they did that, your policy will say complaints made in bad faith will result in disciplinary action up to and including dismissal for just cause. Magic language. It's a freebie there. But you want to make sure that you don't discriminate or that you don't retaliate. Okay, next slide. A brief story. So this goes to Victoria's comment about early on that I would give you a bit of insight into multiple layers. So I'm going to kind of use an anecdote, but also put in a couple hypothetical elements to it. But it's not unfamiliar territory where you would have somebody go be working in a workplace for, let's say, 10 years, and they are a longtime employee, and then the business undergoes a management change. So they decide, you know what, we need somebody who's a bit more tech savvy. We need somebody who understands the market a little bit better. And so we're going to change up our management composition. We're going to get a new manager in here. New manager takes over, and they've got their own way of doing things. And it's not a bad way necessarily. It's just a different way. And so this employee who's been there for 10 years starts to say, wait a second, this isn't the way it's always been under my tenure. I don't like it. I used to get 8s and 9s on my performance eval, or 4 out of 5 out of 10, or 4 out of 5, sorry. I used to do really well on my performance evaluations under Nancy. And now that John's come in, I'm getting 6s out of 10. I'm getting 3 out of 5s. I'm getting notes that I need to improve something. And before you know it, that results in a bullying and harassment complaint, because this person now is maybe in trouble. They perceive that they're being, they're being put under thumb. They're being unduly criticized by this new manager. They're being bullied. And so they may make a complaint, and that may not have merit. And at the end of the day, after a brief investigation, it's found that in fact, those are managerial decisions the manager's making. And the employee is told there's no bona fide merit to what their concerns are, but we appreciate you bringing them forward. Well, that's not enough for the employee, and they go on medical leave because they're feeling stressed by the situation. And they're off on medical leave, and then all of a sudden, 5 of their coworkers come forward and start to say, you know what? It's a safe space now because she's not in the workplace. You know what? Actually, the employee that's now on medical leave, she's been bullying me for the last 2 years. And she's been saying really hurtful stuff about me. And she's in fact got a Facebook group. And she says really nasty stuff about her boss when she goes home every night. And I know there are lots of layers, but this is how it plays out. Victoria, am I wrong here?
No, not at all. A shocking number of the cases we deal with, and it layers on, right? This gets more, and now employees on disability leave, you have their own human rights potentially engaged. Yeah, this is a very common back scenario.
Yeah. And HR is ready to pull their hair out because they're incredibly frustrated by this point because the person's off on leave. You've got complaints about the person, but you don't want to raise them with them while they're on medical leave because you've got a duty to accommodate. So you have to accommodate their absence under the human rights framework. But you've clearly got a conundrum if this person is going to return to work. And you've got to act on these other complaints. And you've got a manager who's, they're doing a really good job, but they've gone in a different direction compared to what this employee was used to. So let's take it another step further. The employee makes a bullying and harassment complaint to WorkSafe. They allege, let's say, mental distress. They put in a claim for mental distress. So now you've got a WorkSafe issue, and WorkSafe's breathing down your neck because they want to make sure that you've got a policy and that you've done everything you need to do. And you have, thankfully, because you've got really good employment law counsel, and they've prepared a really great policy. And I'm not trying to give you a doom and gloom story, but we do see this play out. And so if you've got the policy, you're going to provide that to WorkSafe. And if you've got a narrative about what happened with this employee and the complaints that have come forward, they're going to say this is managerial, this is a workplace issue. That's you're genuinely raising concerns about the employee. There's nothing here. And then they likely will dismiss the complaint or the claim and not allow it. But you're still dealing with it. And if left to the ultimate next step, you could be dealing with somebody who's alleging then constructive dismissal. So not only do they not have a work safe complaint that's passing muster, which frustrates them, they're now going to start saying that they can't come back to work. They're on medical leave and you've created a toxic work environment, and their lawyer sends you a letter saying you owe them, a year's severance. And so this is where the documentation becomes really important, and the duty to accommodate and getting a bit of good advice. But this is not unfamiliar territory for us. In fact, this is the way that many of these situations play out if they get to their final extent. And so the layering is critical. Appreciating that you've got an increasingly complex employment law landscape in most provinces, where you've got WorkSafe, you've got human rights, you've got wrongful dismissal actions that can go through the courts or might support an employment standards complaint. And all you need is a game plan sometimes, just to say, okay, here's how we're going to deal with each of these slivers. But the starting point is understand where they each fit, have a policy, have objective criteria that you use to manage your people, and be fair. I think that's really, really, really important. One of the things about discriminatory prohibited action that I want to flag is sometimes that can arise in a well-intentioned place. So in a construction site, we all see those signs that say like, oh, 270 days since our last safety incident. That's phenomenally important. Really, really important to keep track of your safety incidents. What you don't want to be doing is then chilling the feeling that someone can bring forward a safety concern, because this is safety just like a broken ladder. Workplace toxicity is just as serious as broken equipment, and it will be treated just as seriously by WorkSafe. It's just not as easy to put your finger on as a broken rung on a ladder, right? Can all look at that and say, yeah, I know what that looks like. That's a safety concern. There's a hole in that floor. This stuff is more intangible in some ways, but it's no different when it comes down to having obligations. So just be careful that when you emphasize days without a safety incident or any of those sort of metrics, that you're also leaving space that if people do have issues, you're not disincentivizing them to bring them forward. Okay, and then human rights code. So we talked a little bit about this. Section 13 says you don't want to discriminate against your people based on a mental or physical disability, or if they've got underlying addiction issues, or if they've got something else playing out. So sometimes you'll have I'll just call them a bad actor in the workplace, a bad apple, or at least they're causing a lot of trouble for HR. By asking questions as they bring forward concerns, or as others bring forward concerns about them, you can get at some of these issues that can broadside you. So if there's something happening at home, if there's an addiction issue, or they're coming in under the influence, or they've got something else playing out, you can get at that through these discussions with them over the course of an investigation and by asking good questions. But you're not liable as an employer for something that you didn't or shouldn't know about. So the policy and reporting process is important, because that's information finding. That's how you get at the information that you knew or ought to have known. But once you know it, then you got to act on it. And you want to make sure that you're not opening yourselves up to discrimination issues. And so some of the common remedies that we see from a discrimination perspective, let's say if bullying is related to, sorry, I know I'm kind of zooming through this, Victoria, sorry. Sometimes you'll find that somebody's engaged in bullying and harassment behavior that relates to race, or they're ganging up on an employee because she's from a different country, or she's from a different nation, or she has a different religion, or she doesn't have to work on Saturdays. You know why? Because she's a Jehovah's Witness, and that's your religious accommodation. And so bullying and harassment can hover around these issues, and you get little gangs of people who talk about somebody and, behind their back because they're different, or they've got a characteristic that you're accommodating in the workplace. And so that person can go then, if they feel they're being victimized, and they can make a human rights complaint. And they might get some award of injury to dignity damages, some money to compensate them for the indignity that they've suffered as being discriminated against. There's a make whole remedy. So if they've lost promotion opportunities, bonuses, wages because they've been off due to this discrimination, that can be awarded to them. And then they can get expenses, medical expenses, etc., that they've had to pay out of pocket. No legal expenses. So their lawyer's generally not paid for through a human rights complaint, but some legal expenses incurred prior to the filing of the complaint may be up for grabs. But the big thing to keep your eyes on is that we don't know what we don't know. Employees need to make us aware of whether they've got human rights concerns, but once we know about them, we need to act on them. And once we know somebody's being bullied and harassed, if we don't act as employers, we are then effectively complicit in allowing discrimination to occur in our workplaces. And then these types of damages or these types of remedies are up for dispute. In addition to WorkSafe, and in addition to some of the other toxicity that these situations can create.
Richard, can I jump in here?
Please.
What if I'm an employer with a really well-drafted termination limiting provision? So I'm not that worried about any of this stuff because I know their damages for wage loss are limited.
I get this all the time. I'm sure you do, Victoria, too, where there's a misunderstanding that a contract immunizes you against a bunch of stuff. One of them being any severance liability. And that's generally true in the normal course where you go to fire somebody without cause because they're not a good fit. It can be a really clean departure if the contract is drafted properly and it says you're entitled to employment standards minimums, up to 8 weeks severance. That can be great, but human rights doesn't recognize that. WorkSafe doesn't necessarily recognize that. And so if you allow yourselves to be at the whimsy of a complaint and you don't have proper policies and you don't have proper contracts and you don't follow a proper process, then not to say it's open season. I mean, there are limits to liability, but those bodies don't have to recognize your severance provision because you don't get to go and allow discrimination to run rampant in your workplace. You don't get to allow people to be bullied and harassed and then get away with just the minimums of the law if it results in them being effectively terminated. That's a great point. And WorkSafe and human rights are parallel. They're not one or the other. You can't double dip. You can't have, a person claiming $10,000 for this and then claiming $10,000 in human rights for the exact same thing, like wage loss. You can't double dip, but you certainly could have a WorkSafe prohibited action complaint where somebody says, I whistle blew. I raised a concern about a toxic workplace because a manager was truly bullying me and other people, and I got fired. And the reason I raised that is because the boss was calling me names to do with me being a woman in the workplace, or a man, or being on the gender spectrum, whatever it is. Those are one on top of the other claims. That's where mounting liability can occur. And then you've got the issue of constructive dismissal. So I just wanted to add that into the mix too. If somebody ends up being bullied and harassed in the workplace and they have a meritorious complaint and they truly are being bullied and harassed and they can't really return to the workplace because it's not going to work out, they may have a right to severance and they may be able to sue through the courts for that, but you're going to have a termination clause and that's where that might protect you. But that's enough doom and gloom. I don't want to talk too much about doom and gloom because we're here to tell you what you can do to minimize your risk, not to have situations where you're groping around in the dark to try to find answers for this stuff. Have the proper paperwork in place. You only need one policy in BC by law, and that is the bullying and harassment policy. The landscape's getting more and more technical, more and more advanced as different bodies take on different aspects of law in the province. So employers they got a tough job keeping their eyes on all the stuff that they have to, but that's why we're here, to establish relationships. Victoria, any, I know I raced through that, but is there anything that comes to mind from that discussion?
No, I think I'm going to check our Q&A in a second, but I'm just going to say, in terms of not being doom and gloom, I actually think decision makers really do look at substance over form. Now that cuts both ways for employers, because even if you've documented things or you've set yourself up technically, but there's been some substantive issues, that's not great. But the flip side is, if you've acted in good faith, you've communicated, you've done your best to comply with obligations, and you have an employee who's pursuing a complaint without a lot of merit, even though it might have a lot of merit in their eyes, that's going to come out in the end. You know, you'll all be familiar with the fact that we take a practical approach. So sometimes resolving these things outside of the processes makes sense. But if you do get in front of a decision maker, they're not just going to find blindly in favor of employees.
No. Even
though a lot of this is in place for the protection of employees, they're going to look at the substance of what happened. So in my experience anyways, vexatious or just complaints with questionable merit where an employer has acted properly don't actually get that much traction in the end.
And we had a good question. Sorry, I hope I'm not interrupting.
No, that's what I was going to raise for you.
Yeah, by law, do we not have to have abuse prevention policy as well as harassment prevention? I mean, my take, Victoria, I'd love to hear what you have to say. But my take on this is that we don't typically, as practitioners, see abuse prevention policies per se. It would depend on what abuse is, but if it's violence in the workplace or if it's abuse of one's role, that all can be subsumed in the bullying and harassment policy or the code of conduct that a business might have in place. Do you have any thoughts on that as far as abuse prevention policies?
Yeah, I mean, just that obviously certain industries or sectors are going to have their own requirements. So if you're healthcare or you provide services to disadvantaged youth or your society, there's obviously a number of other obligations that might come into play even in this area. Same as professional code of conducts, of course. If you run a dental clinic, for example, there's going to be some other ethical requirements imposed. So I'm not sure if this is a question that's specific to a certain sector industry. But I think Richard's comment about bullying and harassment being the only policy required references, under WorkSafe's purview. There may be other things required depending on what sector or industry you operate in.
Yeah. And we will be having a really great session next month, and our employer huddle will be geared around managing performance issues when people are suffering from mental health. And Victoria, do you want to tell us a little bit about that?
Yeah, we're going to be joined by a psychologist who's going to be talking about mental health in the workplace with the focus on how that overlaps with performance management. And this is actually a topic I think a number of our lawyers are going to be attending for our own professional development and interests, because it's coming up more and more often, which is what prompted us to try and seek out an expert in this area. Where you have an employee, you're trying to performance manage them, and it turns out that they actually have a mental illness that's potentially contributing to the performance issues. And so, of course, on one hand, you have your obligation as an employer to accommodate those under the Human Rights Act up to the undue hardship. On the other hand, you're also entitled to expect a certain level of performance from an employee, and having a disability, mental or physical, is not, it doesn't excuse any type of behavior. So that's going to be the discussion. Very challenging, very interesting issues, and a different perspective. We'll probably weigh in a little bit on some of the legalities, but the focus will be on getting that outside expert to weigh in.
Absolutely. Thanks for that. And so we will send further information on that. We hope you join us. We also want to welcome you to please contact us with any questions or follow up. We'll be disseminating the materials, and we really appreciate you joining us, and we're here to help. Thank you. Have a great day.